Barr resigns, or did he resign? Was he really politely fired? Why? I'll explain why the job of Attorney General is absolutely impossible for one person who's not schizophrenic to hold. We'll also renew the challenge to YouTube to take down my show with Joel Pollack, questioning the legitimacy of this election on The Durr Show. Joseph Biden is now officially President-elect of the United States. He was elected yesterday by receiving more than 270 electoral votes, according to the Constitution that makes him the next President of the United States. There will be some challenges. There will be some efforts to try to prevent that from happening. There will be efforts to try to get state legislatures perhaps to send two slates of electors to the United States Congress. There will be a move by several members of Congress and perhaps a senator or two to challenge the election results. That will complicate things and delay them. There will have to be a vote of the House of Representatives and the Senate for the election to be turned around. You'd need both houses, a majority of both houses. That's not going to happen. And so I think for purposes of handling the next 4.5 or so weeks, we ought to recognize that the next president of the United States will be Joe Biden. Whether you like it or not, that's the reality. That doesn't mean the president legally, morally has an obligation to concede. All previous presidents who have lost for re-election have conceded, and they have attended the inauguration. This president is different. He may decide he wants to use this election as a springboard to trying to run again in 2024. That's his right. Again, I'm not commenting here on what the best course of action is politically or even morally. I'm a lawyer and a constitutional lawyer, and so I'm laying out the constitutional issues, and the Constitution allows the president to contest the election, to not concede, to run for election again the way Andrew Jackson did, talking about a corrupt bargain. Whether that's a good strategy or a bad strategy, good for America, bad for America, I leave to you. It is constitutionally permissible. There are now really no longer any realistic judicial routes open to the president. The Supreme Court, with the 3 justices he appointed, made it very clear that the courts are not going to get involved in turning around this election. And as I said from the beginning, to have turned around this election in the face of the numbers, there had to be a perfect storm. The judiciary, like in Bush versus Gore, had to intervene. State legislatures had to intervene. State secretaries of state had to intervene. The numbers had to be there. The evidence had to be there, and the clock had to be there. And the clock is running out. The evidence, we heard allegations and presentations, but at this point, nobody's in a position to definitively evaluate the evidence. If my commission were to be set up, the VIP voter integrity panel, obviously these contested issues could be presented to them, and they could have experts, computer experts, voting experts, etc. Give at least an analysis so that the public would not have to rely on the media or politicians to determine what's the truth. The reality is that tens of millions of Americans today don't believe the election was fair. They may be wrong, they may be right, but that's their right, and that's the reality. And it would be better if that number were reduced. I think the Supreme Court decision reduced that number a bit, but remember, the Supreme Court decided the case solely on the issue of standing, a procedural issue that's not so easy to understand, with the dissent of 2 justices. So still, there are going to be tens of millions of Americans who think they was robbed, to quote my Brooklynese. And so we move on. And President-elect Biden has appointed some very distinguished people to his cabinet. There'll be agreements, there'll be disagreements. If the Senate is and remains in the hands of Republicans, and that will happen unless the 2 Democrats in Georgia both win, then there'll be some confirmation battles. Normally, the president is given his cabinet, and there's a difference between confirming a cabinet member and confirming a justice. A cabinet member is the president's choice, working hand in hand with the president, whereas justices are life tenure and they don't work with the president. So the Senate should have a greater role. in vetting and not confirming, if they don't feel it's appropriate, the candidate for Supreme Court justice. Speaking of the cabinet, I want to talk about the resignation of Attorney General Barr. I'm not surprised. The job of being Attorney General, particularly for a contentious and political president of the United States, is an impossible one. Let me tell you what the job description entails, and you'll understand, I think, a lot better why so many attorney generals have resigned, have been fired. It's an impossible job. Here's the job description. President calls you in and says, I want to offer you a job. I want you to be the Attorney General of the United States. Now, you have two roles to play as Attorney General. Listen to the two roles. One, you're in the cabinet. You sit right near me. You're one of the highest ranking members of the cabinet. You know, State Treasury Attorney General. It's the third office. You're fifth in line to be President of the United States. I'm appointing you because you're a great politician. You've been loyal to me. You've helped me. And I need you to be loyal to me. I need you to help me get reelected. I need you to help the Republicans win. I need you to be to me what Bobby Kennedy was to his brother John Kennedy. I need you to be to me what William Smith was to Ronald Reagan when he appointed him Attorney General. Smith had been Ronald Reagan's private lawyer, written his will, knew everything about his personal life. He was the Attorney General of the United States he was appointed while being Ronald Reagan's private lawyer. I want you to be for me what Eric Holder was to President Obama. Close friends, loyal. You have to be loyal. You are my Attorney General of the United States. You have to help me in the Republican Party. All right, you get that? That's half of your job. Now, let me tell you about the other half of your job. You are the Chief Law Enforcement Officer of the United States. In that job, you cannot be loyal to me or anybody else. You must be objective and neutral. You must not let political considerations enter into your decision about who you're going to prosecute, who you're not going to prosecute. You must never, ever, ever allow political considerations to enter into your thinking about whether to announce an ongoing investigation, the way, for example, it was announced that Hillary Clinton was being investigated. No, you cannot do that. You're neutral, you're objective, you're the highest law enforcement official in the country. You're like a judge in that respect. Get it? Those are your two jobs. And the Attorney General designee sits there and says, duh, what are you talking about? How can anybody perform those two jobs at the same time? You want me to be loyal? You want me to make sure that you win? You want me to make sure that I do everything to promote your candidacy, to promote the Republican Party? And you want me to be objective and neutral? Can't be done. Impossible. Schizophrenia. It's not possible to do that job. And it's not possible to do that job. That's why we are one of the very few Western democracies that put these two very, very different jobs in the hand of one person called the Attorney General of the United States. In Great Britain, no, the two jobs. One of them is the Minister of Justice. He has the first job. He has to advise the Prime Minister. He's in the cabinet. He's going to help him maintain his majority. He's going to help him get elected. He's going to do whatever he can to be loyal to the Prime Minister. That's his job. Singular. No other job. There's another person called the Director of Public Prosecution. His job, he's a civil servant. He's not in the cabinet. His job is to make sure that law enforcement is done fairly and honestly and neutrally. The same thing is true in Israel. And there's a perfect example because there you have a minister of justice, highly political. In fact, some of the ministers of justice haven't even been lawyers. They've just been political associates, cronies of the prime minister. It's an important job. You get to be the minister of justice to advise the prime minister how to get reelected, how to maintain his majority. But he doesn't decide who to prosecute. That's in the hands of another official in Israel. It's called the Attorney General. The Attorney General is totally independent. Let me tell you how independent he is of the president. He just indicted the Prime Minister of Israel. Previous Attorney Generals have indicted the President of Israel. In Israel, they don't need special counsel. In England, they don't need special counsel. You don't need special prosecutors because the prosecutors are special. They're independent. They're not part of the political machinery. But in the United States, they are totally, totally integrated. The same man, same job. He gets up in the morning, puts on one sock. That sock says, President's advisor, political, not neutral, help him get reelected. Then he puts on his other sock, and the other sock says, neutral, objective, nonpartisan. Don't do anything to help the president. That will be unfair. He's wearing both socks. Then he puts his shoes on. How does this satisfy the shoe on the other foot test that I talk about so often? It cannot be done. For 25 years, I have been railing against this position of Attorney General, calling for it to be changed, and it can be changed legislatively, creating two offices, one a cabinet position, call him whatever you want, call me Attorney General, call him the Minister of Justice, doesn't matter. The second, the head prosecutor of the United States, civil service, 10-year term, can't be fired by the president except for good cause, swears an oath only to be neutral. We've had such attorneys general. And boy, have the presidents who have appointed them regretted that. The best example is President Bill Clinton. He decided he was going to appoint somebody who he didn't know, a stranger. He had promised his wife that he would appoint a woman. He went through 2 or 3 other choices and they didn't work out. One had a nanny problem, another had another problem. And he ended up picking one of the great prosecutors in American history, Janet Reno, the former state attorney of Dade County, Florida. A distinguished record as an honest and honorable prosecutor. Sure, she was a Democrat, but she was not partisan. She ran for election, sure. But she was known for her neutrality. What a great choice. Except President Clinton spent the next 8 years regretting having done it because she wasn't a loyalist. She didn't help him. She disagreed with him. She didn't take his side when he was sued by various people for sexual misconduct. She was the personification of the second job, neutral, objective, nonpartisan attorney general, but she didn't do the first job. And President Clinton, in fact, never spoke to her during the last years of his administration because he didn't trust her. And he couldn't fire her because it would seem if he fired her that he was trying to prevent an objective, fair, and neutral application of the law to him. Mike Mukasey was a great attorney general, picked after there had been some problems with previous attorney generals, neutral, former judge, perfect for the job. The same thing was true of a man named Levy, the former president of the University of Chicago, who became attorney general right after the Watergate scandal. They needed an attorney general who would not be political or partisan, so they picked Professor Levy, President Levy. Again, perfect for the second job. Terrible for the first job. He wasn't loyal to the president, and the president who picked him didn't get reelected. So we have this schizophrenic job that we call Attorney General of the United States. Cannot be done. You have to pick and choose. Are you going to be wearing the one sock, or are you going to be wearing the other sock? Are you going to be the political advisor to the president, or are you going to be the neutral, objective law enforcement official? With Bill Barr, it was he did both of them, and he was criticized for both. He was criticized by Democrats and people on the left and critics of President Trump for being too political and too partisan in the way he described the Mueller report. Okay. And then he was criticized by Trump supporters and President Trump himself for not being political enough, for not disclosing the fact that Hunter Biden was under investigation, for not proceeding to go after Hunter Biden, and for stating what were his honest views, that the election was not riddled with fraud or error, and that the election would not have turned out differently absent fraud and error. Whether he was right or wrong, he was criticized by the Trump people for not being political enough. So there's no winning if you're Attorney General of the United States. We need to change the job. We need to make sure that there is no conflict of interest. I can imagine no greater internal conflict of interest than an attorney general, decent guy like Barr, wants to do his job, and he has two jobs, and they conflict, and he can't do them both at the same time. So he gets criticized by both sides. He resigns just weeks before the end of the president's term. Maybe he was fired. Maybe he was asked to resign. We don't know the internal dynamics, but we do know that he could not perform his role and satisfy both the President of the United States and his constituents on one side, and Democrats and constituents of the left on the other side. Impossible job. Change it for the benefit of the American people. Now, I'm told that my challenge to YouTube and Google, which I'm repeating here today, remember my challenge. You said you would take down any channel, any video that questioned whether the election would have turned out differently but for fraud or mistake. Whether that's true or false, whether I believe it or not is irrelevant. I had somebody on my show, a distinguished journalist, Joel Pollack, former student of mine, who made that claim. He directly violated Google, YouTube standards. And we have challenged you to take down that show, not take down my whole podcast. You don't have to do that. I don't violate your standards every day. I'm sure I will violate your standards, but I violated your standards in that segment, in that episode of The Durst Show. And you haven't taken it down. And now I'm told that there are callers who are calling in to you and challenging you and saying to you, hey, if you have a standard, comply with the standard. You can't have a double standard. You can't take down 8,000 websites that violate your standard, but refuse to take down The Durst Show because you know if you take down The Durst Show, see you in court. You will be sued. If you take down The Durst Show, we will sue to take away your exemption under Section 230, because the implication of taking down The Durst Show, saying that's not honest, while keeping up other shows that are far, far, far more dishonest and giving them the imprimatur of honesty, because that's what you do. If you take down The Durst Show saying that's dishonest and keep up another show, you're saying that other show is honest. Believe it. You know, we're not taking it down. If we thought it was dishonest, we take it down. That's editorializing. You're entitled to editorialize. The New York Times can editorialize. I can editorialize on this show, but I don't have any exemption. If I editorialize and I state a fact that's defamatory, I can be sued. I can't run to mommy holding 230 and say, mommy, look, I have 230. Please don't come after me. I have immunity. They're treating me like a snowflake. They can't come after me. No. You can't have it both ways. Either you have immunity and you are not involved in making decisions about truth or falsity, or you don't have immunity, and then you can say whatever you please. There are close cases. There are tough cases. Holocaust denial, which is legal in the United States, but illegal in Germany. So I can see you making the argument, look, we are up in Germany. It's hard for us to take down something from Germany, but not from the United States. So we'll take it down because it's illegal in many parts of the world, illegal in Canada, even our close neighbor. Or child pornography. Okay, you can take that down. That's illegal everywhere and should be illegal everywhere. But when it comes to political arguments, was the election fair or not? That's completely different. If you take that down, then you really have to be in the business of editing. You have to be in the business of having a truth commission at Google. People who decide what's true and what's not true. Is Israel an apartheid state? It's all over Google. They've never taken that down. So it must mean you think Israel's an apartheid state. Well, it's not. It's false. It's categorically false. But that's for me and the listeners and the viewers to decide, not for you to decide. So Google, YouTube, make up your mind. Are you a platform? If so, keep my show up and keep up shows and channels and videos that have a different view from you about the election. If you are a publisher, hey, pick and choose. Take down what you don't like. You can run only Democrats. You can run only Republicans. You can run only people that you like, people who pay you advertising. You can do whatever you want, but you don't get exemption from defamation and other kinds of lawsuits under Section 230. So what my program today calls for is a single standard. I want a single standard for the Attorney General of the United States. I want to know what his job is. Hypothetically, if I were called someday, I'm too old for it, but it could have happened in the past. If I were called someday and said by a Democratic president or another president, Alan, we'd like to offer you the job of Attorney General, I'd say, which one? Which job? Which sock do I put on in the morning? Which job do you want me to do? I don't want to do the job of being a political advisor to you. I'm not good at that. That's not what I do. That's not my expertise. But I'd be happy to be the chief law enforcement officer of the United States. And the answer is no, you have to do both. You can't take just one, not the other. You have to do both. That's wrong. That's a mistake. And if I'm called by YouTube and YouTube says, we need your advice, we need your legal advice, what do we do now? I say you apply a single standard. Either you're a platform in which everything but illegal things go, or you're an editorializing publisher, in which case you pick and choose. If you pick the former, you get the immunity. If you pick the latter, you don't. You have to make a choice. Section 230 should be amended to require every single platform to check a box. Make that choice. Interesting to see what Google will do. Interesting to see whether Google accepts my challenge. You've heard my challenges. You've heard my analysis on the Der Show. Now it's time for your points of view. Der Show. Now we need the wits. Our first call today is from Brian.
Hey, Professor Dershowitz. This is Brian McCauley. I'm a law student in California. Really appreciate your discussion today, as always, and in particular about YouTube and the legal theory by which you would pursue them. My question is whether they've already lost their Section 230 cover to the extent they ever will. Obviously, court and probably a few of them would have to see it that way. But anyway, when they say we're limiting this election conspiracy speech as a category, maybe they have some argument that false and defamatory allegations, like that woman made against you, well, they're saying that's not a category of speech which we limit because we don't think it's dangerous in the same way as this conspiracy speech. And perhaps they do have an argument with that. However, it is a far different situation when they make a choice that we're going to let some election conspiracy speech stand, like your interview with Joel Pollak, but this other election conspiracy speech, we're going to take that down, like whatever they've taken down thus far. That's not categorical at all. That's a per se exercise of discretion, is it not? In this line of thinking, they've erred not by taking your episode or your channel down, but by leaving it up. That is just a thought. Anyway, I reported your video to YouTube today through the means which they provide because I want to see them say no or yes on this question. Probably not the first person to think of doing so, but I'm very interested to see whether they act. Anyway, thank you very much for the show. I never miss an episode. Take care.
Thank you so much, Brian. You'll be a great lawyer. Now you've become a whistleblower. You have challenged YouTube. I hope they listen to what you've said and accept the challenge. You're absolutely right. What they can't do is exercise this kind of political nuanced discretion the way I can, the way the New York Times can, the way the Wall Street Journal can, the way Fox and CNN can. They just can't do that and at the same time preserve their 230 exemption. I think you're right. I think they've already lost their 230 exemption, but nobody has sued them as far as I know, challenging that, and I would be happy to make a test case suing them if they in fact exercise their discretion. I have to have standing, and I would have standing to sue them if they took down my episode of my podcast, and I would sue them to take away their 230 exemption. Our next call is from New Jersey. Mel?
I love your show. Usually your analyses are correct. You're being very silly in your challenge to YouTube and Google. When you had Joel Pollak on, he did not say anything outrageous. He said that it may be plausible that under certain conditions, maybe something could have happened that might have affected the election. He didn't go on ranting saying this election was stolen, stop the steal, I couldn't win unless it was rigged. It was rigged. He didn't say anything outrageous like that. So that's the difference. There's no reason for YouTube or Google to take that episode down. There is reason for them to take down episodes that are inciting people to violence. It's not only a question of true and false. I don't think YouTube or Google claims to take down anything that's false. They take down things that are false and that are harmful to the public good. And what Trump has been doing since the election has been immensely harmful to our democracy. And people who aid and abet and support those nonsensical claims of total rigging and unsupported allegations of widespread fraud for which there has been zero evidence of widespread fraud, those should be taken down. And that's why your challenge to them is silly, and you should stop saying it every day. They're not going to take it down because there was nothing wrong with that episode.
You've really made my point, Mel. You say that what Joel said was reasonable and not outrageous, and what others say is unreasonable and outrageous. And that may be entirely correct, but that's not the job of YouTube to determine levels of outrageousness. YouTube has a standard. They say we will not allow our medium to be used by people who raise questions or challenge that the election would have or might have turned out differently but for fraud and or error. And Joel said that. And he said it in a nice, polite way because he's a nice and polite and intelligent guy. But now you're giving YouTube the ability to make distinctions based on how nice the person is, how nuanced their views are. It's exactly what they can't do, exactly what they shouldn't do. You say they shouldn't be determinants of truth, but then you say these allegations are false. Then you add the fact that what about an incitement to violence? Okay, if they had a standard that said we're going to take down anything that incites violence, which is outside of the protection of the Constitution, I would not quarrel necessarily with that. I might quarrel with the definition of or how they apply it, but that's not what they're saying. They're not taking down things that incite violence only. They're taking down things they disagree with. They're taking down things they think, in your words, are not good for America. They're entitled to do that, but not entitled to get the 230 exemption if they do that. Again, what you're missing, I think, is the distinction not between what they can do and shouldn't do and can't do, but whether they get that extraordinary legal exemption, which makes them in some ways even a state actor because they're taking advantage of a state law that the rest of us don't have. I don't have that. I talk in nuanced ways as well, but I don't have the advantage of 230. If I say something defamatory, I can be sued. So with all due respect, I disagree with you. I don't think what I'm challenging them to do is silly. I think it's precisely the point that they're making choices. You are urging them to make choices. You're saying if it's good for America, keep it up. If it's not good for America, take it down. If it's lies, take it down. If it's true, keep it up. And then you move to incitement of violence. You're maybe right about incitement of violence, but I don't think you're correct about these differences between the kind of approach Joel made and the kind of approach made by probably many of the 8,000 that have been taken down. That's precisely for the audience to judge. Or if you think that YouTube ought to make that judgment, fine. But if they're going to make that judgment, they can't take advantage of Section 230. But a great call, made me think, and I think made a lot of the listeners and viewers think as well. Our next call is from Jesse.
I agree with you that as a matter of policy, I don't think YouTube should be in the business of engaging in viewpoint discrimination, although I do think that the marketplace of ideas is not foolproof. You know, and I would give the example of Holocaust deniers. I don't know. I think that YouTube has some obligation to protect the safety of society, given its widespread popularity. At any rate, I also agree with your philosophy about criminal defense, but I do not agree that lawyers should not be condemned for taking on these election fraud suits. I mean, why on earth would William Barr, the Secretary of Arizona, the Secretary of State of Georgia, all volunteer that there was no widespread or significant election fraud to overturn the results of the election if that were not the case?
All right. I understand your point about lawyers, but when I took the O.J. Simpson case, there wasn't a single intelligent or intellectual or serious scholar that I knew who didn't say that it was just as clear as could be that O.J. Simpson was guilty. And maybe he was, maybe he wasn't. That's for people to decide. But everybody said he was guilty, and yet I took the case. When I defended President Trump against an unconstitutional impeachment, virtually everybody in academia said I was wrong. And there were those who called for my discipline, disbarment, or banning from Harvard. And yet I took the case. I think lawyers are allowed to take on very, very uphill battles. We don't accept what the consensus is. Even if every Secretary of State and every lawyer said the election was fair, if the client says it's not, and there is any kind of plausible argument, even if it's the most technical legal argument. Take, for example, the Pennsylvania case, highly technical argument. The legislature basically said all mail-in ballots have to arrive in order to be counted before the close of Election Day. The courts extended that 3 days, which was a good thing to do in light of COVID. It was the right decision morally, but constitutionally it wasn't. And so a lawyer has the right to challenge that, even though it might not affect the outcome of the election. A client, a president, has the right to say, look, if I'm going to lose in Pennsylvania, I'd rather lose by 30,000 than 80,000 votes. So if there's a way of challenging the 50,000 votes, do it. Lawyers have to buck the government and have to buck the establishment and have to buck consensus. That's a very, very important part of their job. So I appreciate your call and I appreciate your concern, but I think the implications of telling lawyers they can't take the case because the government takes a different view brings us a lot closer to China, Iran, and the former Soviet Union than to the traditions in the United States of America. When John Adams defended the Boston Massacre soldiers, everybody in Boston thought the soldiers were guilty. And indeed, in the end, they were found mostly guilty. It was a split verdict. And John Adams, believe me, wasn't invited to dinner and probably suffered some of the same fate among Bostonians as I have suffered among Martha's Vineyarders. But that's the job of the lawyer, to incur that kind of enmity, to challenge the government at every turn, and always err on the side of challenging rather than not challenging. So appreciate your call. Our next call is from Carol.
My name is Carol Zanoni. I am in North Carolina. Just wanted to give you a comment. I'm listening to your podcast, and every once in a while I get a sound that says edit it on it. And this was your podcast about the election, and last Friday, I guess that was the 11th. So I want to let you know that, and I don't know if you know it, but you should know that. Thank you. Goodbye.
No, I appreciate that. I hear it in my ear as well. It's a voice, and it sometimes says edit, sometimes says negative. When I first heard it, I said, wait a minute, who's listening? Who's listening to this show who shouldn't be, and who's telling me what to say? I later found out it was purely a technical glitch having something to do with the internet, and we're trying to deal with it. But if you hear somebody talking in my ear, I hear it as well. Didn't want to stop the show for it, but I understand. So just ignore it the best you can. Hopefully we'll make it go away. I have fantastic people working with me. Kevin, who runs the operation technically. My son, Elon, who helps produce the show. I'm not going to ever blame anything on them, but I'm going to blame it on the gods of the internet. So thanks for the call. Let's turn now to our last call for the day.
Hey, you talked about state legislatures enacting laws to award their electoral votes to the winner of the national popular vote, but you didn't mention that is essentially happening already. There's a agreement called the National Popular Vote Interstate Compact, which 196 electoral votes worth of states have agreed to, which would do that, award all their electoral votes to the winner of the national popular vote, but it only comes into effect if there are enough states to control the Electoral College, 270 electoral votes worth. But I'd just like to get your opinion because there's some debate about the constitutionality of this, because it's an interstate compact, and the interstate compact's clauses have to be agreed to by Congress, but also, like you mentioned, states have the right to choose their electors in any way they see fit. So those would be contradicting each other. And what do you think, if you think this is constitutional or not? Thank you.
Oh, what a great question. You're absolutely right. There is this operation ongoing where a number of states have already agreed, but they agree only if a number of other states agree and make it realistic, because no state wants to give up its electoral votes if it's going to be alone. California, for example, has so many electoral votes. If the state of California voted independently, just on its own, that all the electoral votes of California will go to the person who got the most popular votes, then the state of California might really give up its voters' influence on the election because its voters might vote differently. It wouldn't have happened in recent years because in recent years the popular vote has always gone in favor of the Democrats, and California always votes Democrat. I think Texas would be a better example if they said that even though the majority in Texas is going to vote for the Republican candidate, we're going to send all our electoral votes to the Democrats. They wouldn't do that. But let's assume this compact comes into effect, that enough states pass it. Here's my constitutional analysis. I think that every state legislature probably has the right to make that determination. That is, the state of Texas would independently have the right to demand that its electors cast all of their electoral votes for the winner of the national election. I think the state of Texas would have that right to do that. Whether a compact that compelled them to do it would be constitutional is a much, much harder question. And whether the courts would allow this end run around the Electoral College is another question. I don't think we're going to see enough states enact this. Generally, the states that do it are states that are controlled by Democrats, because Democrats tend to win the popular vote, and Republicans, at least twice, have won the electoral vote while losing the popular vote. So I don't think we're going to get there, but it poses a fantastically interesting constitutional question. Look, as a law professor, I love hypotheticals. They don't have to be real. I love science fiction. Why do I love science fiction? Because it's a series of scientific hypotheticals that tell us what the world could be like, but it isn't. The same thing is true with legal hypotheticals. So legal fiction is another genre because it allows for these issues to be played out. I'm, for example, now watching a show on television called Your Honor, which poses a terrific hypothetical. A judge, honorable, decent, terrific guy. His son is involved in an accident and kills a young boy. And spoiler alert, it only spoils the first episode. But the judge wants the young boy to turn himself in and submit himself to justice, where he'd probably get a suspended sentence and lose his license. But then it turns out that the boy who the young man, the young son, the judge's son, killed is the son of the head of the mafia. And the head of the mafia has sworn that he will kill whoever killed his son. And so the father, the judge, then has to take all kind of illegal actions to save the life of his son. What a great legal hypothetical. Didn't happen, probably never would happen, but it really made me think, what would I do? What would you do? What would any of us do? I didn't want this to be a commercial for a TV show, but it has really gotten me to think a lot. And that's the purpose of anything that is intellectual. That's the purpose of this show. My goal at the end of every session of the Der Show is to have you leave thinking about things that maybe you hadn't thought about before, maybe changing your mind, maybe reaffirming what you believed in and becoming an even stronger advocate for your position. As long as you leave this show thinking, as long as you leave this show a little disturbed and a little shaken up from your previous views, I have succeeded, and I want you back for more on The Der Show. And please call me with questions and comments and criticisms that you have of me and the show. The number is 216-710-0050. 216-710-0050. Call me. I really want to hear what you have to say. You provide the wits that completes the Der Show wits.